next up, we had Daniel Gasteiger in the Ridderzaal. He is working on e-identity and a government stack, an application in Switzerland. And when I mention Switzerland, and when you think about the cryptocurrency space, when you think about the blockchain space, what is the place in Switzerland to be? Zug. That's something I was very eager to learn about. So we asked Daniel, who would you recommend to talk about that? And he came up with Ronald Kogens. And he works in the middle of the space, has experience with that. And I think it's time to take the next step and hear more about why the Switzerland is basically exploding in this ICO and tokenization space, and what's going on with the regulators over there. How are they handling or not handling it? Please, a hand of applause for Ronald.
So, can you hear me? Okay. So first of all, thanks for having me, and also to the AFM and Blockchaingers for making this event. I think it's the right approach. It's really cool that AFM is opening the door and is willing to talk and to look what other people think. As said before, my name is Ronald Kogens. I'm an attorney at law in Switzerland. I'm specialized in IT law, financial market law. In the last couple of months or nearly a year, I'm working mostly on blockchain technology and smart contracts. As I've seen before, most of you have heard about Zug. I'm wondering if someone ever has been in Zug. Maybe you can raise your hand. I mean, it's interesting. There are a few people that have been in Zug, because if you have been there, you know that Zug is kind of a small town. It's kind of a village. It's not really big. It's tiny. It's beautiful, but it has a big name in the world, and that's really fascinating. And I want to talk in my presentation a little bit about what my experience is as a lawyer with dealing with blockchain projects, especially in terms of ICO. What approach that I have to deal with these projects, but then also what these kind of tokens mean under applicable law, what are the challenges, and then what the standpoint is of the Swiss Financial Market Authority. So on the first slide, I mean, why Switzerland? That's a good question. Probably it started because the authorities in Zug said, we're going to accept Bitcoin as payment method for tax or other authority fees. Then we had the Ethereum ICO in Switzerland, which was also a big thing. We have also the Swiss Railway that says that you can buy Bitcoins at their ticket stations. But there are other examples of organizations. We have really good organizations in Switzerland that came together on an early stage and trying to bring the blockchain and the technology to the public. They organized regular events and built up this whole so-called crypto valley. I mean, of course, there are other things like Xapo that moved from the US to Switzerland. And all in all, it's interesting, but if you're looking at the internet, it always says in the communities that Switzerland is a perfect jurisdiction for ICOs. I mean, I don't want to say it's not, but it's still, Switzerland has its laws, and it's not just an unregulated Wild West. So what I've learned working in this field is that I think that's important, and it's something a bit similar to what Lee said, that with blockchain, as a lawyer, you cannot look at the law and then try to qualify the tokens. So what you have to do, you have to first look at the functionalities of the tokens, look what they can do, and then try to classify it under applicable law. So what we did for the qualification and how we look at the different type of tokens is that we're saying it can be kind of a virtual currency, which means it's a simple asset, is a digital code. It's not intended to be a right for a good or a service. When it's going to be accepted, then it can be an alternative payment instrument, otherwise not. So the classical example is Bitcoin. The second three are kind of financing tokens. The first one is the debt token, which can be linked to a loan value for repayment or to a value of an asset. It can also be kind of a bond, or a structured product, a derivative, or another financial instrument. But it's then usually with a repayment obligation. The third category is the equity token. An equity token can represent a partial share or a participation certificate. The owner of an equity token has, depending on the structure, a right on dividends, and it's clearly depending on the success of the company. Then the fourth category are the participation rights tokens. This is something interesting because sometimes people also talking about dividends, but under Swiss law it can't be a participation certificate because there is a numerous clauses on participation certificates. That's why it's something new. It's just kind of a contractual right on the company. But it's important to know that the revenue, that you can only have a participation on the revenue and not on the profit, because the profit is subject to shareholders' decision, and as a holder of a participation rights token, you are not a shareholder. So that's usually something that a lot of people are struggling with. Then the last category are the utility tokens. There are a lot of different types of utility tokens. They can be kind of a right to access a platform, a voting right, or anything else, like a right to program on a project. I mean, there's no limitation. So if we look what it means under Swiss private law, so Switzerland is not seeing cryptocurrencies as a legal tender, because this is regulated in the Swiss Act on Currencies, and only Swiss francs is an official legal tender, but it can be an alternative payment instrument if it's going to be accepted by third parties. And that is what's going to happen or happened with Bitcoin. It becomes more and more accepted, so it's an alternative payment instrument. If we look at the financial tokens, they are financial instruments. So in Switzerland, as soon as you got a right to claim for something, and there is no physical certificate, it becomes a non-certificate security, which means when you issue kind of an equity token or a debt token, you have to issue and draft also a prospectus as you would do for a bond or issuing of new shares. The legal distinction between equity token and future rights token is quite difficult. I mean, for the equity tokens, you can say it represents kind of a share or a participation right certificate, but the qualification of the future of the participation rights token is quite difficult because it's kind of a gray area, as I explained before, because of the numerous clauses. If you look at the utility token, there is no clear legal qualification because it clearly depends on the context. If it's a membership right, it's something different or compared to a voting right. When we look now at the regulatory framework, and here I would like to mention also the challenges that I have every day if I look at different projects and talk to the people, is that, for example, the Anti-Money Laundering Act in Switzerland, which says if you are issuing a payment instrument, then you will be subject, you become a financial intermediary and will be subject to the AML law, which means that you have to become a member of a self-regulated organization or a license or a permission by the Financial Market Authority in Switzerland. And I mean, here the problem starts. When you think about that someone, oftentimes people in projects saying, look, I want to have my own token that can be used on the platform to pay third parties that offer their services or goods on the platform, for example, musicians that offer their music on the platform, and the people can pay them with the token. So this simple setup, even if it's limited to a specific platform, can be already a payment instrument. And now the question is, if you have just one time a payment instrument and you issue this payment instrument just one time, is it then really necessary that you become a financial intermediary and have to do all these procedures and go on a yearly basis to different events for education and have all this procedure in place because you just one time issue a new payment instrument? Is it not enough if you just work with another company together that is already regulated subject to AML? And I mean, these are questions that we raise now and that we have to talk to the regulator in Switzerland and look what the solution will be. Another point is the Financial Market Infrastructure Act in Switzerland. So as said before, as soon as you have a right to claim in something, the token becomes an uncertificated security, which means it's a security. But also there, a security in Switzerland is not the same, and there are not the same consequences as if it is a security in the US. Basically, if it's just a security, it doesn't mean that you have registered a token with the Financial Market Authority. No. But if you're offering kind of a platform for the exchange of securities, then it's something different because then you're becoming an organized platform for exchange of securities, which requires a permission. But also here, it's very challenging for me as a legal guy without a real deep technology background to talk to the people from the projects to really understand what they want to do. Because, I mean, that at the end, you can write a lot of things on paper, but it's much more important that the project itself is structured according to what stands on the paper. And this is quite a big challenge because when you go a little bit deeper and talk to the people, then you see that sometimes it's not quite correctly reflected on the paper what it actually is. Another thing is that oftentimes projects which are very interesting, I think, that people trying to pool funds from the public and then invest this in different projects. I mean, the approach is very nice, and especially if the money is pooled and will be invested in third world countries to develop them. But also there, you're coming close then to a collective investment scheme. And if you are becoming a collective investment scheme, you need a permission by the Swiss Financial Market Authority, which means it takes at least 9 to 10 months, and it costs you the whole setup, something around 100,000 Swiss francs or more. I mean, also there you see that the technology taps into the net of the regulatory framework, and it's not just doing something because it's new and you can do it. It's also there regulatory law applies. If we look at the Banking Act, that also is something that is oftentimes challenging because, I mean, even if you look at the ICO itself, when you're getting the funds from the people, you have to make sure that you're not holding the funds for more than 60 days, because if you're holding funds for more than 60 days and from more than 20 people, you're accepting public deposits, which means you're a bank and you need a banking license. And I mean, as consequence, it's clear in Switzerland you need 10 million at least as a company, and you have to have many internal procedures to become a bank. So it's not that easy and probably not the right thing for a startup company. But also there, I mean, it's a thin line, and you're getting really fast, or it's very. I mean, in this project, you're really close to becoming a bank, and you're kind of far away of not becoming a bank, and this is a really thin line. And that's why, for me as a legal advisor, I mean, my job is not only look at the terms and look at the paper to saying, yes, that's right, I'm done, for me it's fine. I mean, I'm becoming more an advisor. I'm working together with people that are drafting smart contracts, but also people that are looking at the economics of the tokens, what it means from a business perspective, but also with people that are doing the security audit of a smart contract to ensure that it really complies with what I'm drafting on the paper. And I think that's the only way that you can ensure that you are doing something that is in line with law, but also is something solid from a technical perspective. So I am on my last slide. I would like to give you some insights on how the regulator in Switzerland works, what they are doing. So I can say the Swiss Financial Market Authority is very open-minded. They are open to talk. They have a special FinTech desk where you can send your idea by email. You can call them and talk to them. But FINMA clearly said in its latest guidance that the law in Switzerland is technology neutral, which means that only if something is a new technology does not mean that the law is not applying. So they issued the first guidance. It's a really short guidance, but they had to do something because, as said at the beginning, Switzerland is a kind of an epicenter of initial coin offerings. Sometimes I'm getting 4 or 6 requests a day just for providing legal advice. And it's a really overheated market because everyone believes that maybe something changes also in Switzerland and they have to do the ICO as soon as possible, otherwise it's over. But it's definitely not the case because the FINMA clearly stated that they are interested in the technology and that they give the technology a chance. But you have to look at what it means, a concrete project under applicable law. So what you can do in Switzerland and what I do if I'm advising on initial coin offerings, first I'm trying to bring the idea and the project down on the paper. Then I'm doing a legal qualification. I think about what it means under applicable law on from the regulatory side, but also on private law. And then FINMA is willing to look at this, and you can ask FINMA for a pre-assessment on their view. That's really nice, and it's a really good approach, I think, because they give you a chance to get a feeling on how they think. And that's the most important thing here, because we don't know as legal advisors how they think, and they don't know how we think. I can show them how the view is on the market, how it is to work with the people from all these projects, and they have kind of the background on how they think the laws have to be interpreted. So if you send such a request to the FINMA, it's not taking half a year, so they're saying it takes 3 or 4 weeks, and usually it is only 3 or 4 weeks, but they also clearly saying they are not legal advisors. So which means that you have to do your own due diligence. You need to think about the project, so you have to create a project that you saying this is the final project and that is what I want to do. And you need also someone that looked at it from a legal perspective that is saying that's what we think it is, that's how it qualifies under law. And then it makes it also easier for them to look at it because then they know, okay, they had a legal advisor or a legal person that already looked at the project itself and made a qualification. So then they only look at it and maybe challenge it or saying that they have something additional or are not 100% or are not 100% agreeing with what is standing in this kind of description. All in all, it's very difficult. It's a very difficult field, and it's very challenging also for the authorities. They are working on more full guidance than they issued recently in September, because the September guidance was really short. It was just a 2-pager. It was not comparable to the one of the SEC. But the person I talked to, FINMA, they clearly said, look, we need to get more experience in it before we can give a clear guidance. We need to gain our know-how to provide something to the market that makes it much more clear and stable compared to just issuing something and then we see afterwards it makes no sense. And I think that's absolutely the right approach, and it's also not the time yet to issue or to regulate this kind of new technology with blockchain and smart contracts. It makes much more sense to have an open discussion and talk to each other and exchange what makes sense or what could make or what should be changed in the future or just to issue clear guidance on how to do things. Because my experience is clearly, and also as stated before by Lee, that no one or most of the people are not intending to do illegal things. They just don't know what it means and on what they have to look at it. And I think clear guidance is probably the most important thing, and also an open conversation to find for the future the right approach to deal with this new technology. So this was it already from my side. I don't know if you want to take question now or then on a later stage, Rutger.
First, a hand of applause for Ronald.